Vice Chair McLean,
Here.
Committee Whip Andrade,
Here.
Ranking Member Williams. Here. Representative Alupas.
Here.
Representative Arrington,
Here.
Representative Bell,
Here.
Representative Barrero,
Here.
Representative Bush,
Here.
Representative Fine,
Here.
Representative Harding,
Here.
Representative Hawkins,
Here.
Representative Panchowski,
Here.
Representative Lamarca, Representative Mariano,
Here.
Representative Maney,
Here.
Representative McCurdy, Representative Morales,
Present.
Representative Trabulsi,
Here.
Representative Tuck,
Here.
Representative Valdez.
Present.
We have
Thank you. Let the record show that a quorum is present. Please remember to silence all electronic devices. Be recognized by the chair before addressing the committee of the presenters, and make sure your microphones are on after you have been recognized and when voting on a bill. In order to abide by the COVID guidelines, please remember to keep your face mask on at all times when speaking at the podium. This applies to members and the public. Members, today we have 7 bills on the agenda, and we will begin with CS for House Bill 173 by Representative Tant. Representative Tant, you're recognized to present CS for House Bill 173 and individual education plan requirements for students with disabilities.
Thank you, Mr. Chair. Thank you, Vice Chair McLean and Ranking Member Williams for hearing my bill. I appreciate the opportunity. House Bill 173 strengthens the workforce path or transition services for students with disabilities in our schools, and it has passed its first committee of reference. Just as our workforce and career planning bill for non-disabled students does, this bill also requires planning for the workforce path for disabled students starting in middle school. So that's the first thing that this bill does. And so this will result in students entering high school with a plan for immediate appropriate workforce and career goal education at age 14 instead of 16. There's 3 things that parents need to be notified of in this bill. One is requires for parents and students to be informed about existing transition, career and technical programs and collegiate programs offered at their school district, and the amazing post-secondary collegiate and career tech programs available across our state through this Florida Center for Students with Unique Abilities. The bill also requires teachers to provide parents and students in IEP meetings with a list of existing state resources that can help support their loved ones so that they can maximize their outcomes in life. And then finally, the bill requires the transition teachers to review with parents the ability to defer a diploma in order to continue their educations from ages 18 to 22. Lastly, the bill authorizes the Department of Education to conduct an internal review so that they can come up with standardized best practices for their school districts. That is the bill, Mr. Chair.
Thank you, Representative Tant. Are there questions on the bill? There's one amendment. Representative Tant, you're recognized to explain Amendment 219171.
Yes, sir. This is an amendment that is just a clarifying amendment because some students don't have parents, they have guardians. So this allows the guardian to be involved in the decision-making process. And it also clarifies that if a student has reached the age of majority and can make their own decisions, that they can do so as well. So it's just a technical amendment.
Thank you, Representative Tant. Do members have any questions on the amendment? Is there any objection? Show the amendment adopted without objection. We're back on the bill as amended. There are appearance cards. Jane Johnson, Florida Association of Centers for Independent Living waves in support. James McFadden, Autism Speaks waves in support. Debbie Mortham, Foundation for Florida's Future waves in support. And Dr. Danielle Thomas, Florida PTA. All righty, thank you for being here. Members, is there debate?
debate, Mr.
Ranking member, you're recognized in debate.
Thank you very much. Representative, I appreciate you bringing forth this bill. This is a great bill. This shows how we have someone that will speak for those that can't speak for itself. I really appreciate you putting forth this bill. Thank you.
Representative Trabulsi, you're recognized in debate.
Thank you, Mr. Chair. And Representative Tant, I'd just like to say I've really enjoyed the conversations that we've had just over the past several weeks, not just regarding this bill, but people with unique abilities. And I love that, coined that phrase. But just learning about deferred graduation was very shocking to me, to know that people can't go back and receive those services, and to know how important this is. So thank you so much for bringing this bill.
Any other members in debate? Representative Hudchowski, you're recognized in debate.
Thank you, Chair. Representative Tant, I just want to thank you for this great bill. I love how you have taken your personal experience and your passion, and you have turned it into amazingly good policy for the state of Florida. So I just want to thank you so much for this bill.
Representative Lamarca in debate.
Thank you, Mr. Chair. Representative, thank you for spending the time yesterday to talk with me and share
Please.
background of this bill and why it's important. I wouldn't have thought 10 years ago that the chair of the Broward Republican Party and the Florida Democratic chair could sit down and have a conversation, but it's a great bill and I'm supporting it.
Thank you.
Any other members in debate? All right, seeing none. Representative Tant, you're recognized to close.
Waive closed. Thank you.
Thank you, Representative Tant. Missy, please call the roll.
Representative Zalufis?
Yes.
Andrade?
Yes.
Harrington?
Yes.
Bell?
Yes.
Ferrera?
Yes.
Bush?
Yes.
Fine?
Yes.
Harding?
Yes.
Hawkins?
Yes.
Punchowski?
Yes.
Lamarcus?
Yes.
Mariano?
Yes.
Maney?
Yes.
McLean?
Yes.
McCurdy?
Yes.
Morales?
Yes.
Trabulsi?
Yes.
Tuck?
Yes.
Valdez?
Yes.
Williams?
Yes.
Chair Latvala?
Yes.
21 yeas.
By your vote of 21-0, CS for House Bill 173 will be reported favorably.
Thank you. Thank you.
Congratulations. Next, members, let's go to CS for House Bill 131 by Representative Duggan. Representative Duggan, you're recognized to present House Bill, or CS for House Bill 131, Educator Conduct.
Thank you, Mr. Chairman. Members, too often school employees can engage in sexual misconduct with a student and evade any consequences by moving among schools, districts, and employers. According to a 2017 study, half of perpetrators had prior allegations of sexual misconduct with students, and 1 in 3 had multiple victims. By creating employment screening tools, processes for schools to use when hiring personnel, and prohibiting the employment of perpetrators, this bill can prevent further victimization of our children. The bill does the following. It prohibits public, charter, and private schools that participate in state scholarship programs from employing perpetrators of sexual misconduct with a student. It creates a duty on employers to report perpetrators for inclusion on the Department of Education's disqualification lists. It requires school districts to execute an affidavit of separation that captures the circumstances of a former employee's termination or resignation in lieu of termination. It requires the Commissioner of Education to determine probable cause within 90 days of receipt of a legally sufficient complaint against a teacher for sexual misconduct with a student. And finally, it requires that school districts complete their investigations and determination of sanctions related to misconduct within 1 year of receipt of a legally sufficient complaint. That is the bill.
Thank you, Representative Duggan. Are there any questions on the bill? Ranking member for a question.
Thank you. Do we have a percentage of amount of employees that's returning or have had sexual assault complaints against them? Do we have a percentage? How many teachers are we talking?
You're recognized.
Thank you. So just to clarify, this bill would be more than just teachers or administrators. It would be any school employee who has conduct with students. I don't have the answer to that question, but I'll work with House staff to see if we can get you one. Thank you.
Any other questions, members? All right, there is one amendment. Chair Ingoglia, you're recognized to explain Amendment 887633.
Thank you, members, and thank you for the opportunity to present this amendment. Members, a couple of weeks ago, I was made aware of a school employee in my district that was charged with 3 counts of lewd and lascivious battery on a child under the age of 12. He was arrested on campus during the school day. Later that day, parents received an innocuous robocall that an employee had been arrested on campus, but was never given the details and the reason why. It was the school district's judgment that the parents did not have a right to know, and I vehemently disagree with that. And so do the parents and constituents in my district, and I have a sneaking suspicion that many in the state of Florida agree also. Parents have an absolute right to know when, where, and if our children had been in contact with an alleged pedophile. School districts should not have the option to hide this information, as uncomfortable as it may be, from parents. To rectify this, this amendment requires that parents receive notification within 24 hours when a school employee that has had direct contact with students is arrested for charges relating to the abuse of a minor. And the reason for that is parents can use this information to facilitate conversations with their children. It requires a principal or administrator of a public school, charter school, or private school that participates in a state scholarship program to include at a minimum the employee's name and the charge for which he or she was arrested in the notification. Members, I know that safety of our children is at the top of our priority list. This amendment makes sure that parents receive proper notice and will never be left in the dark again. I ask for your favorable support on this amendment.
Thank you, Chair Ngoglia. Do members have any questions on the amendment? Is there any objection? Show the amendment adopted without objection. We are on the we are back on the bill as amended, and there are 3 appearance cards. Debbie Mortham, Foundation for Florida's Future, waves in support. Antonio Verdugo, CFC Florida, is a proponent. Dr. Danielle Thomas, Florida PTA. Thank you very much. Members, is there debate on the bill as amended? Representative Fine in debate.
Thank you, Mr. Chairman. I want to thank you for bringing this great bill forward. In my district last year, we learned that a assistant coach and a substitute teacher had been fired for sexual misconduct. He had apparently met one of the students and sent her inappropriate photographs and was fired. My school district, because he was politically connected, never reported the termination to the Department of Education. And as a result, he was not only able to get back into schools, but no one knew, and he ran and was elected to the City Council of Palm Bay. His name is Kenny Johnson, and kind of an odd last name given what he did. But it shows that there are problems in the system when people can do this sort of thing, get away with it, and then get back into the schools and troll for more victims, which he was trying to do. So I appreciate what you've done. I appreciate what you're doing, and hopefully this makes sure issues like what we had in Brevard County that don't happen again.
Members, any other debate? All right, seeing none, I actually am going to debate on this bill. And I want to read some examples. Criminal conduct is not investigated and the teacher is not disciplined. For example, in March 2019, a certified middle school teacher stood trial in Miami-Dade County for sexual assault and rape of students over a 15-year period. According to the Miami Herald, while complaints were filed against him, quote, he rose into the teachers union circle, unquote. The first student complaint against this teacher dates back to 2004. Allegations against him included forcible rape, child pornography, inappropriate text messages, unwanted sexual touching, groping a fellow teacher, and verbal sexual comments. He remained at the same middle school until his arrest in 2017. Also, inadequate personnel records and processes that do not disqualify future employment. For example, many times teachers resign before the completion of an investigation and are subsequently employed because they were never formally charged. For example, in Hillsborough County, 5 teachers who resigned while under investigation for wrongdoing later returned to the classroom through a company that provides temporary workers for the school district. Of those 5, 2 worked as substitute teachers after resigning. In Broward County, a substitute teacher was fired after allegations of sexual misconduct, and the school district disqualified him for future employment. Because the allegations were never reported to the DOE, he was certified as a teacher and subsequently hired by a charter school in the same district. Also, untimely investigations by districts and DOE. It took almost 2 years for the school district to terminate a middle school teacher after his arrest on charges he molested a 12-year-old girl in 2017. Conditions of his arrest include no contact with children. So the district put him on administrative suspension with full salary and assigned him to the school district's book depository. According to the Sun Sentinel, and I quote, "The school district was waiting for the criminal case to end, but decided to move forward because they couldn't fill his teaching position until he was removed from the payroll." While documented complaints of misconduct against the teacher dated back to 1998, he still found employment at other schools in the district. His certification remains active according to the DOE website, yet his case is working through criminal court in Broward County. Also, moving schools while continuing direct contact with students. Here's another example. After being arrested for soliciting prostitution and entering a deferred prosecution agreement, a PE teacher was reinstated and moved to another middle school within the district. Less than 2 years later, the teacher was arrested on charges of lewd and lascivious battery on a 13-year-old victim. While his criminal case remains open, he was on administrative suspension, and his certification, according to the DOE website, is still active. With that, Representative, you are recognized to close on your bill.
Thank you, Mr. Chairman, and thank you for those words of support. Members, I hope you find yourself shocked and disappointed that these protections aren't already in place for our children. And for those of you who are returning members, the House has passed this bill. I've run this bill for the last 2 years. It's passed unanimously through all committees and off the floor. It came to me as a passion project and through a circumstance that the chair alluded to. I was out campaigning in 2017, knocked on somebody's door, asked them what issues they cared about, and they told me that their child had been sexually, molested by a teacher at one of our premier charter schools in my county. And I promised her that if I got elected, I would do everything I can to make sure that nothing happens to anybody else's child as happened to her child, because the perpetrator on her child had done exactly this, had done it elsewhere, had been caught, had resigned in lieu of termination and moved on and got hired again and nobody knew. So my hope is that the third time is the charm, and we're going to get it done this year. And with that, I ask for your support.
Thank you, Representative Duggan. Missy, please call the roll.
Representative Zalupas,
Yes.
Andrade,
Yes.
Harrington,
Yes.
Bell,
Yes.
Guerrero,
Yes.
Bush,
Yes.
Pine,
Yes.
Harding,
Yes.
Hawkins,
Yes.
Panchowski,
Yes.
Lamarcus,
Yes.
Mariano,
Yes.
Maney,
Yes.
McLean,
Yes.
McCurdy,
Yes.
Morales,
Yes.
Trabulsi,
Yes.
Tuck,
Yes.
Valdez,
Yes.
Williams,
Yes.
Chair Latvala,
Yes.
21 yeas.
By your vote of 21-0, CS for House Bill 131 will be reported favorably.
Thank you. Thank you all.
Congratulations. Next, let's take up CS for House Bill 519 by Representative Yarborough. You are recognized to explain required health education instruction. Representative Yarborough, you are recognized to explain your bill.
Chairman, thank you. Good afternoon to you and the Vice Chair and the Ranking Member, members of the committee. Thank you for putting this bill on your agenda for consideration today. Members, Florida requires bullying prevention education in our schools through the Jeffrey Johnston Stand Up for All Students Act, and also now trafficking prevention education with our Department of Education rules. However, there is no child sexual abuse prevention education. So the bill before you, in addition to not burdening schools with anything new, will implement the preventative education that is age appropriate, related to human trafficking, exploitation, and also child sexual abuse, which is often a precursor to trafficking. I appreciate that Rep. Valdez brought up in a prior committee about funding, and she asked the good questions about that. And I did want to let you know that funding is already provided through the AG's office and also through the Department of Education. That's the main thrust of the bill. The other piece in the bill is you will see some language related to abstinence education and also teenage pregnancy. That is not new language. We're just moving it into a different section to make it more appropriate to be taught in grades 6 through 12 versus leaving it wide open all the way down to the kindergarten level where you wouldn't really have the same type of instruction taught in the elementary levels as you would in the middle and high school levels. But that's not new language. It's just moving it to the appropriate section. With that, Mr. Chairman, that's the bill for your consideration.
Thank you, Representative Yarborough. Are there any questions on the bill? There are no amendments. There are no appearance cards. Is there debate? Seeing none, Representative Yarborough, you're recognized to close.
Thank you, Mr. Chairman. Just to leave you with a few statistics, and you probably heard these before. It's sad we have to mention them, but about 1 in 10 children will be sexually abused before their 18th birthday. About 1 in 7 girls and 1 in 25 boys will be sexually abused before they turn 18. And this year, there could be about 400,000 babies born in the U.S. that could become victims of child sexual abuse unless we do something to stop it. And all of those are Care of the Darkness to Light campaign to end child sexual abuse. So we definitely have a need for this, and I appreciate your favorable consideration and ask for your support. Thank you.
Thank you, Representative Yarborough. Missy, please call the roll.
Representative Zalufas?
Yes.
Andrade?
Yes.
Arrington?
Yes.
Bell?
Yes.
Ferrero?
Yes.
Bush?
Yes.
Fine?
Yes.
Harding?
Yes.
Hawkins?
Yes.
Benchowski?
Yes.
Lamarcus?
Yes.
Mariano?
Yes.
Maney?
Yes.
McLean?
Yes.
McCurdy?
Yes.
Morales?
Yes.
Trabulsi?
Yes.
Huck?
Yes.
Valdez?
Yes.
Williams?
Yes.
Chair Latvala?
Yes.
21.
By your vote of 21-0, CS for House Bill 519 will be reported favorably.
Thank you, Chair and Committee.
Next, let's take up Representative Barnaby's bill, and that is CS for House Bill 1027. Representative Barnaby, you're recognized to present opening remarks at high school athletic contests, and feel free to take off your mask if you need to.
Thank you, Mr. Chairman. Good morning, Mr. Chair, Ranking Member. Mr. Chairman, the bill requires that sporting athletic associations in Florida allow schools participating in high school championship contests to make brief opening remarks, 2 minutes or less, using the public address system if the school would like. Furthermore, this bill requires the athletic association to announce prior to the school's opening remarks that the content of the remarks is not endorsed by the association, nor does it reflect the views or opinions of the association. The association may not control or monitor the remarks, content, or control the school's choice of speaker. The bill also provides that the decision to allow opening remarks at regular season contests is at the discretion of the school as well. That's the bill.
Thank you very much, Representative Barnaby. Are there questions on the bill? Oh, I'm sorry. Ranking Member, you're recognized for a question.
Thank you, Mr. Chair. I'm currently at a sports event. Do they already have the right to invite someone out to speak, or is this already taking place? And if so, why are we creating a bill?
You're recognized.
Thank you, Mr. Chair. Thank you for the question, Ranking Member. This bill, Ranking Member, is necessary because nothing is codified in state law that would allow this to proceed. And this is why this bill is necessary.
Do you have a follow-up? No. Any other questions for Representative Barnaby? Who I might add is a freshman member. All right. And there are no amendments. There is an appearance card. Brooks Bayless, you are recognized to address the committee if you'd like. we expect a good presentation.
Yes, sir. Good afternoon, members. My name is Brooks Bayless, and I'm a sophomore at Mckay High School. I'm here representing myself. First, please allow me to thank you for all the sacrifices you've made to serve our state in the Florida House. I'm here today exercising my First Amendment right to petition my government. I appear before you in support of Representative Barnaby's House Bill 1027. I'm a believer that the First Amendment is perhaps the most important part of the U.S. Constitution because the amendment guarantees citizens freedom of religion and speech. When Cambridge Christian School faced off against another university Christian high school in the Class 2A state championship football game, they asked the FHSAA they could do a prayer before the game. The association said no. They wanted to do the prayer so their players and fans could pray before the game. I believe that the FHSAA's actions violated the First Amendment. Unfortunately, over the last 5 years, the issue has not been resolved by the courts. Although I'm only 16, based on my understanding of the separation of powers, the Florida legislature is empowered to clarify that at athletic events in the state of Florida, speech, including prayer, is protected. By passing Representative Barnaby's bill, the legislature would be doing just that, protecting this state, protecting the First Amendment in the state of Florida. Thank you for your time, members, and I encourage you to support this important legislation.
Thank you very much for being here, and I understand that you are the son of a pretty powerful lobbyist around here. But you are here representing yourself, correct?
Yes, sir.
Are you receiving any compensation for your testimony?
No, sir.
Because usually when he appears before us, he's doing it, you know, as representing one of his clients.
Yes, I understand that. I am not entitled to any compensation.
You should perhaps talk to your father about, you know, some compensation that you may be due for your appearance here today, because you did a wonderful job.
Thank you. We might have to work something out.
And I may want to talk to you about some reforms that we can do to FHSAA
Sounds good.
in the future.
Thank you so much.
Does anybody else have any questions for young Mr. Bayless? All right. Well, thank you very much for being here.
Thank you for your time.
Members, is there any debate? All right. Well, seeing none, Representative Barnaby, you recognize the close.
Waive close, Mr. Chairman.
Thank you, Representative Barnaby. Missy, please call the roll.
Representatives Alupas,
Yes.
Andrade,
Yes.
Arrington,
No.
Bell,
Yes.
Ferrero,
Yes.
Bush,
Yes.
Fine,
Yes.
Harding,
Yes.
Hawkins,
Yes.
Punchowski,
No.
Lamarcus,
Yes.
Mariano,
Yes.
Maney,
Yes.
McLean,
Yes.
McCurdy, Morales,
No.
Trabulsi,
Yes.
Tuck,
Yes.
Valdez,
No.
Williams,
No.
Chair Latvala,
Yes.
15 yeas, 6 nays.
By your vote of 15 to 6, CS for House Bill 1027 will be reported favorably. Congratulations.
Thank you, Mr. Chair. Thank you, committee.
Next, let's take up Chair Graw's bill, and that is House Bill 241.
Thank you, Mr. Chair. Thank you, committee, for hearing the Parents' Bill of Rights today. HB 241 creates a new chapter of law to clearly define the rights of parents regarding the way in which government and institutions interact with our children, and to articulate to our agencies and institutions the importance of the role of family in establishing and implementing policies that impact parents and children. It sets forth legislative findings. In Section 4, it indicates that a parent's right shall not be infringed upon with regard to the upbringing, education, healthcare, and mental health of our children. Section 5 enumerates certain rights but does not limit those rights. Section 6 sets forth parameters for a school district to promote parental involvement and to establish policies working with parents to present those to parents. And Section 7 talks about parental consent for healthcare purposes. That is the bill, Mr. Chair.
Thank you, Rep. Grall. Members, are there any questions on the bill? All righty, seeing none, there are no amendments. There are some. Ron Watson from American Freedom Information Institute waives and support. Carrie Boyd, SPLC Action Fund waives in opposition. Karen Woodall, Florida Center for Fiscal and Economic Policy waives in opposition. Ida Escamani from Florida Rising waives in opposition. Kara Gross, American Civil Liberties Union of Florida waives in opposition. Anna Catherine Hammett, Parental Rights, Florida. You are recognized.
Good afternoon. Thank you, Chair Latvala, for placing this bill on the agenda. My name is Anna Catherine Hammett, and I'm 14 years old. My parents are John and Dana Hammett. For as far back as I can remember, my parents have been there, watching, helping, and mentoring me so that I can be the best person I am supposed to be. Parental rights shouldn't have to be dictated, and most certainly shall not be infringed upon. I know that as a minor, I am not capable of making certain decisions by myself. In these situations, I call on the wisdom I know my mother or father will provide. I cannot imagine how making an life-altering choice without the counsel and advice from people who love me more than their own life. The fact that we have to ensure that parental rights are specified and respected is very upsetting and disturbing to me. I support this common sense bill because I understand that parents are the future generation's guardians, teacher, and confidant, all wrapped in one amazing package. It can be frustrating at times being a minor and knowing that there are certain things my parents will not allow me to do. But I know that I will look back, and instead of bemoaning the fact I wasn't allowed to participate in certain activities, I will praise God and thank my parents for protecting me from evil. This bill is necessary, not optional, and I ask you to please vote yes and prioritize the protection of children, their parents, and their rights. I would also like to state that all these words are my own. It was my decision to come here today and my opinion that I have been expressing. Please, the Parents' Bill of Rights is indispensable, crucial, equitable, and I plead with you to vote yes in favor of the Parents' Bill of Rights. Thank you for your time.
Thank you for being here. You did a wonderful job. Lakey Love, Florida Coalition for Transgender Liberation and Tallahassee National Organization for Women. You're recognized.
Thank you, and thank you for allowing me to speak in front of you today. My name is Lakey Love. I am a member of the Florida Coalition for Transgender Liberation. We are a group of 26 different organizations, mostly transgender-led, but also allied to faith groups and organizations across the state of Florida. We strongly oppose this bill on the grounds that it would force professionals and staff inside the school system to out students on the basis of sexual orientation and gender identity, thus creating a more hostile and unsafe school atmosphere for LGBTQIA+ children. We also take a lot of disrespect for the lines 174 through 183, which redefine objectionable materials and allow a parent to petition for copies of software, handouts, workshops, applications, meaning like apps, online apps, and digital media on the basis of an opposition that to the materials that are being taught on the basis of morality, sex, and religion, or what the parent might deem as harmful. We're worried that LGBTQIA+ history, the women's history, the Black and brown history will be called out by parents that object to these kind of teachings. We are also worried about the undue economic and labor burden that this will place on the school board and the superintendent, because later in that section 6, it does say that a parent has the right to receive all of the materials they've requested within 10 days after writing the superintendent. They do not receive those materials, including applications, right, and digital content, that they can appear in front of the school board, thus tying up the school board with one parent's objections. And we know that we have groups that Bird Dog, LGBTQ, and Black and Brown history teaching in the state of Florida, white supremacist-led groups that are already looking for content that they find objectionable online. Thank you.
Thank you very much for being here. Barbara Devane, Florida National Organization for Women, is an opponent. John Harris Moyer, Equality Florida. You are recognized.
Good afternoon, Chair and committee members. My name is John Harris Maurer, and I'm here representing Equality Florida, the state's largest civil rights organization dedicated to securing full equality for Florida's LGBTQ community. Equality Florida appreciates that there have been improvements made in this bill from what we heard last year, based on concerns from the public. But our primary concern still remains that this bill could compel outing LGBTQ youth in their schools. The LGBTQ community values parental rights, including the rights of LGBTQ parents. Unfortunately, we know the reality is that not all parents come from supportive households. A story came out in the media when we were talking about this bill last year about a young boy in Polk County whose dad left him on the side of the road on Highway 27 with no food, no water, and no shelter because they suspected he was gay. And those are the kind of parents that we have to keep in mind when we are working on legislation like this. We know that a lot of LGBTQ youth come out at school before they come out at home. Sometimes those schools are the only places of safety for LGBTQ youth. So what we want to ensure is that this bill has flexibility for school counselors and therapists to consider whether they could be endangering LGBTQ youth by disclosing information like sexual orientation and gender identity. And it's not just about sexual orientation and gender identity. We know that students can also disclose information about other issues that they're seeing in the home, whether those are things like substance abuse, alcohol abuse, or domestic abuse. And compelling these educators to disclose that information to parents can again endanger our young people. So we urge strong caution on this bill.
I have a couple questions.
You're recognized.
I know I listen to so much of this. Just quick question. You told this horrible story about this child left at the side of the road. Is that not a crime today, like child abuse, to take your kid and just leave him on the side of the road?
I would certainly hope that it is, but it goes to the point that not all parents are supportive and loving as we might be inclined to expect.
Okay. Follow up?
Yes, sir. You're recognized.
And I'm sure coming out as gay or lesbian is a difficult decision, but if a child has chosen to keep it to himself, if he hasn't told anyone at school about that, how would this bill have the parents find out about that child's beliefs? How would they be outed to the parents if the child hadn't disclosed those feelings or opinions to someone at school?
You're recognized.
Thank you, Chair. Sure, the bill is based on disclosure in school records. So that young person would have had to tell a teacher, school counselor, what have you, about their sexual orientation or gender identity. And if that record then exists in the system, there are no safeguards in the bill for that counselor or teacher to consider whether, in notifying a parent, they may be introducing that young person into a hostile environment.
Follow up?
Final follow-up. Yes, sir.
Okay, thank you. So it is your position that it is the role of schools to protect children from their parents. Is that correct?
You're recognized.
Thank you, Chair. It is Equality Florida's position that schools should not be endangering LGBTQ youth.
I'd have more questions, but I'll stop.
Thank you for being here.
Thank you, Chair.
Kenneth Neipman, and I apologize if I mispronounced your name, Florida Conference of Catholic Bishops.
Thank you, Chair. It's Kenneth Kneetman, but that's a great try.
My
Thank you,
apologies.
sir. No worries, sir. We want to thank, my name is Ken Kneetman. I work for the Florida Conference of Catholic Bishops. We are the official policy arm of the Catholic Bishops of Florida. We want to thank Representative Grahl for her bill, and there are just 3 quick points that I would like to make to you. The first being, it is a fundamental right of parents to direct the upbringing, care, and education of their children. Children need to be raised and represented by their parents. Government officials and institutions are not co-parents. Secondly, parents have the right to important information regarding their children when those children are interacting with public agencies. With very few exceptions, information regarding health, education, and the well-being of children should not be withheld, either inadvertently or on purpose. Finally, parents have the right to expect complete transparency regarding the instructional material to which their children are being exposed. Institutions have an obligation to be transparent, forthcoming regarding content and activities. Thank you.
Thank you for being here, sir. Dana Hammett, Parental Rights, Florida. You are recognized.
Thank you, Chair, for including this on your agenda as well today. I appreciate the opportunity to share my heart and my concerns with you. My name is Dana Hammett. However, to 4 wonderful and unique individuals, I'm called Mom, a title that I not only cherish, but consider a call to love and to protect those who refer to me in this way. I've been blessed with the privilege of being a parent for 28 years now, a role in which I embrace the responsibility of raising these precious ones above all else. I would give my very life for them. I have made my share of mistakes along the way, and I'm obviously not perfect, but I am the one who is perfect for this job. There is no one on God's green earth who knows my children as I do, who loves them as I do, and who has their best interest in mind as I do. There are far too many things as a parent to be responsible to list here in a child's journey to adulthood, but making decisions on behalf specifically of their health, both mental and physical, their education, are my decisions. As their parent, it's my fundamental right to decide for my children the direction they should go in each of the aforementioned things, and I want to be assured that that would not be infringed upon. It's my fundamental right to choose what education they receive, what form of health care best meets their individual needs to promote positive growth in their lives. While we can all agree that not all homes are safe and some children do need intervention in the home, the majority of parents have the best interest of their children in mind. The beauty of House Bill 241 is that it allows for parents to make the best decisions on behalf of their minor-aged children while not removing any laws or protections in place for children in compromised conditions. Passing this common sense bill into law would protect children and families from undue infringement by government agencies upon the rights of parents by consolidating the currently scattered and confusing statutes into a concise and easily understood law. I ask you to put Florida families first today and to vote yes for House Bill 241. Thank you for your time.
Thank you for being here. Valley Osborne, Parental Rights, Florida. You are recognized.
Thank you for the chance to speak today. I'm here in support of the Parents' Bill of Rights, and I want to quickly share a real-life scenario from Okaloosa County, in which the local teachers union intervened in a school district investigation to defend a special education teacher who was physically and verbally abusing her nonverbal, autistic 4-year-old preschool student. The union argued that the timeline of the investigation violated the terms of the teacher's contract, so they negotiated with the school district to get the case nullified and closed quickly. The parents were never notified that their nonverbal child was a victim of abuse at school. Surprisingly, there's no requirement for schools to disclose this information to parents. No action was taken against the teacher, and the report was never entered into her personnel file. The investigation was buried for an entire year until the parents received a tip about the report's existence. The parents learned that the mandatory reporters within the school district neglected to file a report against one of their own. Only with the involvement of the parents did a criminal investigation get launched. The case ended with multiple arrests, a federal court case, and the governor's suspension of the superintendent of schools. If it weren't for the parents' involvement, this abusive teacher would still be interacting with nonverbal special needs students. Scenarios like this prove that government agencies sometimes are influenced by special interest groups to take actions or choose inactions that benefit their stakeholders, even if it violates the rights of others. We need the legislature to preserve parental rights so that we, the parents, can serve to protect our special interests, our children. Please vote yes today to protect our most vulnerable. Our nonverbal special needs students need you. Thank you.
Thank you for being here. Patty Sullivan, Parental Rights, Florida.
Good afternoon, Chair. Thank you for hearing this bill today. I'm Patty Sullivan, representing Parental Rights Florida. We're a grassroots movement of Florida parents. We're all volunteers. We have no paid staff. We have no paid lobbyists. Valley, as you just heard, drove 4 hours to be here, and this is the second time in 2 weeks that she's done so. And I live 6 hours away, and I would be here no matter what. We do this purely with absolute love for our children and our families and our future generations of Floridians. Senator Rodriguez, the Senate sponsor of the bill, recently said, he said, strong nations begin with strong families. And strong families begin with parents in charge of their own children. This is a very common sense thing. And it's confounding to me that we even have to have a law that says that. But clearly, with all that's going on, especially in the last year in Florida, I have stacks of files that I could show you right now on an Excel spreadsheet of how violations are happening more and more against the parental rights right here in our own state. And common sense does say that children belong to parents, not the government. A decade ago, right here in Florida, 2011, Florida legislators almost unanimously passed a historic memorial that affirmed parental rights as fundamental. And so this has been 10 years in the making. And it is now time to demonstrate good faith to Florida families to pass this common sense Parents' Bill of Rights into law. So with each passing month, like I said, here in Florida, we hear more and more stories. Recently, right here in Representative Fine's district, the school district put out information that made it clear that they believe they can withhold a child's personal information from that child's parent. This means that the school district can decide what the parent does or does not have the right to know about their own child. This is completely unacceptable. Government is not the parent of our children. With these and many other stories of increasing infringement on Florida parents and families, our legislators can now lead the effort in passing this common sense bill that will give clarity to the parents, to the agencies, and to these other entities that really need clarity. And I was one of those children, I'm in my 50s now, but I was one of those children who was abused by a female teacher. And I was bullied by her. And I was tormented for years to keep from telling my own mother. She was the one that I should have been able to tell. So again, we cannot put our children, their best interest in these government entities' positions. Parents have that right. There are millions of neighborhoods throughout Florida, and we don't know what's going on in those homes. But we have to trust and believe that there are laws that deal with abuse in families. And there are laws where they can go in and take care of that abuse. So that shouldn't be an issue. So we want to be families with our children. And as parents, we do love our children. And we want to raise them to be productive, happy citizens. So on behalf of Florida parents, our children and our families, we respectfully ask for you to vote yes today. And we ask the House and the Senate leadership and all representatives and senators to not only support this, but to co-sponsor it and demonstrate to Florida families that we matter, because we are the citizens. You represent us, and we want to see support of this. We want to thank you for choosing to put Florida families first and pass the Parents' Bill of Rights. Thank you very much.
Thank you for being here. Antonio Verdugo, Christian Family Coalition, Florida. You are recognized.
Thank you. Thank you, Mr. Chair, Vice Chair, and committee members. And I do, before I begin, want to preface my remarks by echoing the previous sentiments and urging all of you to co-sponsor this bill. This is a nonpartisan bill, not about being a Republican or a Democrat, liberal or conservative. That doesn't matter. I am the executive director of the Christian Family Coalition of Florida, one of the state's largest human rights organizations. And we do urge you to vote yes on HB 241. Detrimental and life-changing proposals are being filed to undermine parents' rights every day. Parents do have veto power over objectionable materials in schools. It is not the government's role and not extremist groups either. We must preserve the rights of parents to make decisions for their minor children. You know, parents are not the problem. Parents are the solution. Let me repeat that again. Parents are not the problem. Parents are the solution. And it doesn't take a village to raise a child. It takes a loving family, of which we're blessed in Florida to have. So again, we strongly urge you to please vote yes. Parental rights are under assault in the state of Florida, and we need your support now more than ever. Thank you.
Thank you for being here, sir. Armando Pomar, Hispanic American Diabetes Foundation.
Yes, sir. I waive support.
Thank you for being here, sir. And that is the last of the appearance cards. Members, is there debate? Representative Harding in debate.
Thank you, Mr. Chairman, and thank you, Representative, for bringing forth this really good bill. I've been called a lot of things in my life. The favorite thing is dad, 4 times. And I just couldn't help think as we just sat here and heard a bill that we had to run because school districts weren't reporting that a child molester and a pedophile work for their school. And essentially the argument against this bill is that school district should have more authority over my child's life and what they learn than me. And so as we're sitting here, I went and got on Public School Review's website and they have a lot of, it's a pro-public school website and have a lot of information on here. And you look up parental involvement and it's the #1 tie to the success of your child from elementary school to college. And they lay out the top 5, you know, and academic achievement, parental involvement leads to better behavior, and you could go on and on. And so not only do I support the bill, I find it offensive that there are people that want those school districts to have more say over my child than me. And so I probably support this bill and thank you for bringing it forward.
Members, any other debate? Representative Fine in debate.
Thank you, Mr. Chairman, and I echo everything you said. I was actually here in my notes to make those points as well. In preparation for the bill, I think we're going to do shortly, you tend to learn a lot about public education. And I studied how Thomas Jefferson, one of our founders, he's one of the creators, by the way, of the whole notion of public education. And as he designed it more than 200 years ago, he thought public education should be managed not by a superintendent, not by teachers, not by principals, not by bureaucrats. He thought public education should be overseen by parents. My, how far we have fallen. Frankly, it's a sad day today. It's a sad day that we need a bill like this. It's even sadder, the opposition that we hear to it. We literally heard that it is the role, that they believe it is the role of bureaucrats to protect children from their parents. And had I asked a few more questions, I think I would have been able to expose the lunacy of the argument, but I will simply make here. He said the child might have issues if the parent knows about it. How on earth is some bureaucrat sitting in a school going to have any idea what is going on in my family with me as a father or my wife as a mother or any of your families? The arrogance at the notion that some bureaucrat knows better how to raise my child than I do. Now, that doesn't mean there are not bad parents out there. There are. But when you use as an example a crime where someone should go to jail as the argument for this bill to be defeated, I think it's simply offensive. I think it's appropriate that this bill, by the way, is sandwiched between Representative Duggan's bill. Now we talk about Parents' Bill of Rights, and soon we're going to talk about school choice, where parents can actually get their kids out of these systems that do these kinds of things. Since my school district was brought up, I'll just close with this. A few weeks ago, my school district said it is the role of the Brevard Public Schools to raise children. It is the role of Brevard Public Schools to protect children from their parents. With this bill, we're going to protect parents and children from these out-of-control bureaucrats. And so I'm proud to co-sponsor the bill. I echo the call for all of you to do the same because we need to send a message to these people. They have it wrong. Parents are in charge, not bureaucrats. But thanks for running the bill.
Members, any other debate? Representative Hanchowski in debate.
Thank you, Chair. I appreciate the intention behind the bill, but I'd like to take this opportunity to thank the guidance counselors that I've had in my life that were there for me in difficult times during school. I'd like to thank my parents who were very involved and made sure that I went to a school where they trusted how I would be taken care of and educated there. I would also like to thank every single teacher, guidance counselor who helped with our children. I was a very involved parent, still am, even though my children are 20 and almost 23. Very active in the PTA. I volunteered. I traveled around the country with the debate team and everything. And yet I still also worked with the teachers and trusted the teachers in the schools I'm in. And I just bring that up while absolutely parents should be involved. There is working with those schools and those people who are around our children 8+ hours a day. Thank you very much.
Representative Valdez in debate.
Thank you very much, Mr. Chair. And I do appreciate your bill, Representative Grawl, and I understand where you're coming from. Serving as a school board member for many, many years and being actively involved in my schools and my district, oftentimes, even in PTA meetings or football games, or you didn't see the parental involvement. It's very difficult when you see students and kids that when they look out in the audience out there, they don't see a parent. Some of these kids are raising themselves. And to Representative Fine's point about being against the law and things that are criminal should be treated as such, sometimes they go unmet and unseen. And if it not for guidance counselors, teachers that are constantly there at school activities, because we all know that to coach a soccer team, you need a teacher. You need someone that's going to step up and do that job. Parental involvement and parental rights, absolutely. I am a mother of 3 and abuela to 4, soon to be 5. And still today, still am involved with my family. It's a shame that you have to dictate to adults that bore these kids, that you're responsible for them. It really is a sad day. I agree with the speakers there. It is a sad day that we have to come to this point. And by the same token, looking at things holistically and making sure, because we represent everybody in the state of Florida, not just the Christians, not just the parents, but what about those children that have nobody? Who's going to represent them? And this is why I'm concerned about the bill, because lucky are the children that have 2 parents that love them and are there to support them. But how unlucky it is for our children in the foster care system that are bounced around from household to household. How unlucky are they when they don't have the guidance of 2 parents that love them? For this reason, I can't support your bill because I'm thinking about all of the children, not just those that have good parents. Because at the end of the day, good parents are always going to be there for their child. And they will find a way of going to that principal or going to that school and having an adult-like conversation. But for those children that have nobody, I am their voice today. So I respectfully will vote no against this bill because of those children that have the luxury or does not have the luxury of having a household with two loving parents. Thank you.
Representative Trabulsi in debate.
Thank you, Chair, and thank you, Representative Grall, for this bill. I know we've had a few conversations about it, and I understand your passion. I knew that I was going to speak today on behalf of the bill because I think so much of it too, and have such high respect for you. But I wasn't sure how until I started listening to everyone's stories and the people that got up and spoke. And when I was in school, there was a young boy, he was my age, we were seniors together, his name was Jimmy Thompson. And his parents were going through a divorce and he didn't know what to do. And he went to a teacher and told them. And I'm sure Jimmy's parents loved him. We grew up together. We went to school from kindergarten through high school together. And his parents loved him, but they just kind of lost sight of what was going on in Jimmy's life because they were so consumed with theirs. And so Jimmy went to a teacher and told them what was going on and how depressed he was and how it was causing so many problems in his life. And the teacher chose not to say anything to his parents because he didn't want to upset his parents any further. And Jimmy took his own life. And his parents had the right to know, even though they were consumed in something else, they had the right to know what was going on in Jimmy's life, and perhaps he would have been here today. So although we all may not be perfect parents, I know that I'm not. My kids are all adults and I'm still a helicopter mom. And they thank me for it today. They didn't thank me for it for a long, long time. But we're all raised differently. We had dinner last night and talked about different obstacles we had in our lives as children. But at the end of the day, we are our child's keeper, and we have the right, the fundamental right to be their keeper. And if there are things that are going on in the home or with the child, parent has a right to know. And if there are things, I think someone mentioned abuse, well, teachers are already required to report that, as they should. So I thank you for this great bill, and I hope it passes through the House, through the Senate, and the floor. You have my support 100%.
Members, anyone else wishing to debate? Representative Maney in debate.
Well, let me preface this. Thank you, Mr. Chairman. Let me preface this by saying I typically don't speak in committees. I typically don't make comments. Perhaps that's due to my previous careers, but I want to thank all the people who came and testified today. But I was particularly moved by the comments regarding an incident in Okaloosa County. It's where I had the privilege of presiding as a judge for almost 29 years. The comments were absolutely on point. If anything, they minimized the situation that we had in Okaloosa County. I'm the proud parent of 2 and the proud grandparent of 6, and I think parental rights are absolutely critical. And I appreciate bringing the bill. I'm proud to vote up on it when that time comes. Thank you.
Anyone else wishing to debate? Well, the judge will have the final word, or the last word. Representative Grall, you are recognized to close on your bill.
Thank you, Mr. Chair, and thank you, committee. Thank you to those of you who have already co-sponsored the bill. Thank you to those in the Democratic caucus who have reached out and have tried to understand why we've heard the narrative that we have in committees. Because as I challenged the last committee, read the bill. Read the bill very specifically and see where your objections may be, because I think it's difficult. We've heard about this bureaucracy that interacts with parents. This is meant to provide a roadmap to the parents and to the bureaucracy to say this is how we should interact together, because that exists in so many different places in statute, that exists in case law. sometimes this should help with the training of teachers and the way that they interact with students. But we have seen across the state areas where I know the teachers are mandatory reporters. There are different policy positions that school districts take around this state about whether or not a teacher is going to report a crime that happens to a child. This bill says you have an obligation to tell the parents that a crime has been committed against their child if you have not called DCF or law enforcement. Because if you are not going to follow your obligation as a mandatory reporter, then you should have an obligation to let that parent know that a crime or a potential crime has been committed against a parent. We've seen the complexity of the bureaucracy around us marginalize parents from a system that they don't feel like they can navigate. Every child, I know every child does not come from a two-parent household, but even parents who I have a law degree, it's still challenging to get through the bureaucracy. Parents shouldn't need a lawyer to get through the bureaucracy of our agencies and institutions that interact with our children. There should be an expectation that that parent's involvement is the ultimate success, is ultimate to the success of that child. And that just isn't existing right now in terms of the culture. And so what this seeks to do is to lay that out and to really put families first. And that's all families. That's every type of family. That's single parent families. That's two parent. It's all families. Because we, as parents, have the best interests of our child at heart, not the institutions. And with that, I'd ask for your favorable support today. If you aren't going to support the bill today, I'd ask for you to give it more consideration before it goes to the floor. And my door is always open to talk through the concerns that have been raised. But I do not believe that the unintended consequences that have been used to scare people about parents' rights will actually come to fruition should this bill become law. Thank you.
Thank you, Rep. Grau. Missy, please call the roll.
Representative Zalupas?
Yes.
Andrade?
Yes.
Arrington?
No.
Bell?
Yes.
Guerrero?
Yes.
Bush?
Yes.
Fine?
Yes.
Harding?
Yes.
Hawkins?
Yes.
Panchowski?
No.
Lamarcus?
Yes.
Mariano?
Yes.
Maney?
Yes.
McLean?
Yes.
McCurdy?
No.
Morales?
No.
Trabulsi?
Yes.
Tuck?
Yes.
Valdez?
No.
Williams?
No.
Chair Latvala?
Yes.
15 yeas, 6 nays.
By your vote of 15-6, House Bill 241 will be reported favorably. Congratulations. And as was previewed a few minutes ago, we will now go to PCB EEC 2101, School Choice by Representative Fine. You are recognized to present the PCB.
Thank you, Mr. Chairman. And let me start by saying that it is a privilege to be your partner on working on this bill and to work on it side by side with you. I'm pleased today to present the Florida House's School Choice Bill for the 2021 legislative session. This bill is long and lengthy, and I'm happy to answer questions on it, but at its fundamental, it does three things. The first thing the bill does is it reduces complexity without consequence. We have multiple school choice programs that all do the same thing and create confusion. Mckay, Gardner, family empowerment. This will shrink down those numbers of choices while having the same scholarships, but with fewer entry points. It will also make it simpler to be in these programs because it will not require parents to jump through hoops every year to get renewals. Second is it increases the amount of money that many students will get in their scholarships. Traditionally, we have provided 95% of the funding that a student would get in a public school. Withholding 5% of that funds, we're going to increase that to 100%. And in addition, for what is today called the Mckay Scholarship, where we do not provide all of the categoricals or all the funding associated with the categoricals. Sorry, I'm echoing. Those categoricals will now be incorporated into the scholarship amounts while grandfathering students in this new program so no student is hurt versus what they have today. And then finally, And I think this is a big change. This will dramatically increase the number of children who have the availability, if their parents so choose, to be able to take advantage of school choice. Representative Grawl talked about the importance of Parents' Bill of Rights. Well, some parents say, look, I don't want to deal with this anymore. And for whatever reason, they want to put their children in an alternative situation. We are going to dramatically increase the ability for low-income children to gain access to these, as well as, I apologize, I think
They're looking into taking care of that, Representative.
no worries. I think it may be that microphone right there, that speaker. I'll hold this down here. Maybe it'll be better. But it will allow the children of military, foster children, adopted children, and others to gain access to the scholarship without being subjected to a cap. And those are some of the highlights of the bill, Mr. Chairman.
Thank you very much, Representative. Are there questions on the bill?
Valdez has questions.
Okay, Representative Valdez, do you have questions? Oh, nobody has any questions?
I'm trying
Oh,
to
do
find.
you have a question, Representative Valdez?
Well, I do. I was just trying to find the line item, the line where we talk about the students obtaining their IEPs. I believe that, okay, it's in, thank you for your help there. It's in line, the sentence begins on line 565, where it says the school district shall notify a parent who has made a request for an IEP that the district is required to complete the IEP and matrix of services within 30 days after receiving notice of the parent's requests. The school district shall conduct a meeting and develop an IEP and matrix of services within 30 days after receipt of the parent request in accordance with the State Board of Education rules. Representative Fine, my concern with that is that in the traditional public schools, parents or students that need an IEP that are also generated by request of the parent, or sometimes even from the teacher's perspective that they're seeing that the child might need to have an IEP. The district has 60 days to complete that IEP and require all of the documentation in order to help that child. Here, we're giving parents 30 calendar days. So for me, that's a little bit troublesome in the sense that at that point, the parent that's requesting a voucher will jump over a kid who has been in the pipeline waiting to receive the IEP service. And although, as you know, I am a proponent of school choice, I am very concerned of the inequities of that particular section, because we are definitely going to have a backlog. And if you look at the IEP team, there's always a shortage of personnel. So there's a backlog of these IEPs going on. So my concern is with that, how do you think that would work with all of the things that I have just described? And are we going to preference voucher children over children that have been waiting for that? To me is inequitable, and I'm concerned about the child, period, end of story.
Representative, everything that you are describing is current law already. Representative Fine, if you would like to say more than that, you are welcome to be recognized.
Thank you, Mr. Chairman. There's nothing about this bill that would create prioritization for the IEPs of voucher children over non-voucher children. In fact, this provision of the bill describes for all children. If you'll look at line 551, it's school district obligations. And if you look at the paragraph above, they're just talking about other things. This is about the development of IEPs. And while we do increase the time or make it faster for them to get them, I'm less concerned about workloads on bureaucrats and I'm more concerned about children getting the education they need as quickly as they can.
Follow up, sir?
Yes, ma'am, you're recognized for follow-up.
And I recognize that it is current law, with all due respects to both of you. I understand that. Why don't we just make the law equitable and say that IEPs need to be completed in 30 days regardless of the kid? Because again, I'm not concerned about the bureaucrats. I'm not concerned about anything. I'm concerned about that child in either system, whether it's public, whether it's voucher. If it's 30 calendar days that we're going to be doing for voucher kids, voucher parents that want this service, and I'm all for it. I'm not against it. My thing is that public school students will have 60 days to have this particular service done, whereas we are stating here that after 30 days, after notice of the parent in 30 days, that must happen. Whereas with the traditional public schools, parents have 60 days. So there's that inequity for me. So why don't we just make it all 30 days if that's the case for any child?
Representative Valdez, remember, we're in questions.
That's
so-
my question.
okay.
Why
Re-
can't we?
Representative Fine, you're
Thank you,
you're
Mr. Chairman.
recognized.
I will look into that issue, but I believe if you read the language of the paragraph that you're referencing, it doesn't say the parent of a student with a disability who is seeking a voucher. It says the parent of a student with a disability who does not have an IEP can get one in 30 days. I think the concern that you have is actually addressed by the bill.
Representative Valdez, would you like a follow-up?
I will not have a follow-up question, but I would like to, with your indulgence, Mr. Chair, speak with staff to see the comparable statutes that this will also protect traditional or applies to traditional public school students as well, so that then, because my concern, sir, is really the benefit of the child. I'm
Yeah,
not worried about the adult.
staff of the committee works for everyone on the committee.
Yes, so I
So
just want
they
to,
will be happy to assist you.
thank you, sir.
Any other questions, members? Oh, I'm sorry. Representative McCurdy. you're
Thank you,
recognized
Mr.
for a
Chair.
question.
Representative Fine, good afternoon. Lines 432 through 445 and page 18. My question is, does this bill allow for parents to use the voucher to fund a prepaid college program?
You are recognized.
I'd encourage you to read the lines that you referenced. Lines 432 says contributions to the Stanley G. Tate Florida Prepaid College Program or the Florida College Savings Program pursuant for the benefit of the eligible student. The answer to the question is actually in the lines that you have just referenced.
I just wanted a yes or no. I'm sorry.
Yes, sir, you're recognized.
So I just wanted to make clear for those who have some reservations that this bill will take funding from current intended K through 12 students now to be used now for future
Is there a question?
college from years down the line, correct?
You're recognized.
This portion of the bill speaks to the choices that parents can make. This bill, there's nothing about this bill that diverts funding as it relates to these ESA to any particular purpose. That will be a decision of parents as they make the best decisions for their children.
Another
Yes, sir,
question.
you're recognized for follow-up.
Representative Fine, are private schools currently required to provide transportation?
You're recognized.
No.
Why are they receiving a portion of transportation
You're
categorical?
recognized for follow-up.
Sorry,
Yes,
Mr.
sir.
Chair.
Do you want to restate your question? I
Yes.
apologize.
I just want so if private schools are not required to provide transportation, then why are they receiving a portion of the transportation categorical allocation?
You're recognized, Representative Fine.
We fundamentally, thank you, Mr. Chairman, we fundamentally believe as a matter of policy that the funds should follow the student. So when we fund the transportation categorical, we are funding it for a child if they qualify to get transportation to school. If that child is no longer being transported to that school, those funds are no longer needed, and those funds should follow that child to the school that they choose to go to. And by the way, maybe they will say to said private school, I'm not going to your private school. The school that one of my children goes to offers some form of transportation, and maybe that's part of the factor that some parents choose when they're making that decision.
Would you like a follow-up? Okay. Any other questions, members? All righty. There are no amendments, and there are some appearance cards. Philip Suderman, Americans for Prosperity, Waves and Support. Debbie Mortham, Foundation for Florida's Future, Waves and Support. Carrie Boyd, SPLC, Action Fund, Waves and Opposition. Catherine Boehm, Florida Education Association, you are recognized. Thank you for being here.
Thank you, sir. And I was a little surprised you got my name right. I appreciate that. Thank you. Committee members, I am Kathy Boehm from Florida Education Association. And Chair Latvala, I know your schedule did not allow us time to meet, and we look forward to talking to you soon about our concerns. And I apologize to you, Representative Fine. Had I realized you were presenting the bill, I would have requested a meeting with you as well, and I will follow up with that. We have many questions about the impact of the bill. In the first year, this legislation moves all voucher students currently in Gardner program into the FEFP under the empowerment vouchers and expands the program. On the policy side, the net effect would be to shift over 20,000 students who have been funded through a direct appropriation over to the school district's responsibility. But the bill analysis suggests an indeterminate cost. There's so much uncertainty with next year's student enrollment for existing students. This may not be the time to make large structural changes in our funding mechanism for public school students. That many students amounts to over $200 million in additional costs. Indeterminate is not really the same as cost neutral. And this bill clearly is not cost neutral for school districts. Additionally, the teacher salary increase allocation that so many of you worked on last year is included in this bill as a categorical to be shared with the voucher students, even though the private schools are under no obligation to use it for salaries. This will dilute your good efforts to address persistent teacher shortages, especially our ESC teachers. We ask that you retain existing statutes for this provision. The third concern is equitable transparency. As a parent, I would want to know that 2/3 of the students that are included in the annual tax credit voucher study are in private schools where the average test scores show negative learning gains. If we do not address school performance, parents have no basis for their educational decisions. In a free market, government would not handicap one business while boosting another. But this bill maintains a systemic bias by requiring different performance metrics for private schools compared to public schools, and by making performance transparent for only one subset of private schools. I will be happy to share the data with you so you can see for yourselves what I see. For these and many other reasons, we ask you to vote no on the bill. We do hope you will work to make changes to ensure all of our children have equitable access to safe and effective schools, and parents have access to data they need to make good decisions. We would like to work with the sponsor to that end. Thank you.
Thank you for being here, ma'am, and I look forward to meeting with you. Members, is there a debate? All right, seeing none, Representative Fine, you're recognized to close on your bill.
Thank you, Mr. Chairman, and I will be brief. My door will remain open to everyone. This bill will be working. We have a Senate version of it as well that we have to sort of work through over the next several weeks. The reason the cost is indeterminate is we don't know how many parents are going to choose to avail themselves of these options. That's the way it should be. The government shouldn't be deciding what parents' choices are going to be. As it related to the comment about different performance metrics, I would challenge the previous speaker on that notion. We can make the performance metrics the same for private schools and public schools, but it comes at a very grave risk. Do you know what happens to a public school that underperforms year after year after year? They continue generally to underperform year after year after year. Do you know what happens to a private school that underperforms year after year after year? The parents say, I'm done with this school. They take their kids out and it closes. That is the ultimate way that we have the accountability in private schools. If we want to make the playing field the same, then we would have to say that private schools could never close either. And I don't think any of us want to do that. I think this is the time to make these changes because education is going through a transformation, not only here in Florida, but around the country as well. 46 states have not done what Florida has done and given children the right to go back to school. We have, and I think part of the reason we did and part of the reason the governor did it is because he knew that parents would have lots of choices. We lead in giving parents the ultimate option on what is best for their children. This bill will take that to the next level. We need to do it, and the time is now. The best time is now. And with that, I ask for your favorable support.
Thank you, Representative Fine. Missy, please call the roll.
Representative Zalupis.
Yes.
Andrade.
Yes.
Arrington.
Yes.
Bell.
Yes.
Ferrero.
Yes.
Bush.
Yes.
Fine.
Yes.
Harding.
Yes.
Hawkins.
Yes.
Punchowski.
No.
Lamarcus.
Yes.
Mariano.
Yes.
Maney.
Yes.
McLean.
Yes.
McCurdy.
No.
Morales.
No.
Trabulsi.
Yes.
Tuck.
Yes.
Valdez.
Yes.
Williams.
Yes.
Chair Latvala.
Yes.
18 yeas, 3 nays.
By your vote of 18 to 3, PCB EEC 2101 will be reported favorably.
Thank you, Mr. Chairman.
Congratulations.
Thank you, members.
Members, I think that ends our work for the day. We have one more bill, huh? I was just making sure Representative Bell was paying attention.
I've got it right here.
Representative Bell, you're recognized to present House Bill 793, Measurement of Student Performance.
Thank you, Chairman Latvala and members. I know all of you are hungry, so I'm going to make it really quick. I'm honored to present to you today House Bill 793, Measurements of Student Performance. This bill will assist school districts in making timely assignments to instructional personnel before the start of school year. It requires the Commissioner of Education to release the VAM, which is Value Added Model, data by July 31st instead of August after school starts, preventing the disruption of classrooms. If you put it in layman's terms, you take your first grader to school to meet their child before school starts. They start school a week later, the teacher didn't grade out, and so the classrooms are now disrupted and your child's moved into another room. So this is just moving the date earlier so that there's no disruption. And that is my bill, Chairman.
Thank you. Are there any questions? We have an hour and a half if y'all want to come up with some questions to ask. All right. Seeing none, there are no amendments. There are 3 appearance cards. Wendy Dodge, Polk County Schools, waves in support. Angie Gallo, Alliance for Public Schools. Thank you for being here, waves in support. Dr. Danielle Thomas is a proponent. Thank you very much for being here. Members, is there debate? Guess not. Representative Bell, you recognize the close.
We've closed, sir. Thank you.
Well done. Thank you, Representative Bell. Missy, please call the roll.
Representative Zalupis.
Yes.
Andrade.
Yes.
Arrington.
Yes.
Bell.
Yes.
Ferrero.
Yes.
Bush.
Yes.
Fine.
Yes.
Harding.
Yes.
Hawkins.
Yes.
Punchowski.
Yes.
Lamarcus.
Yes.
Mariano.
Yes.
Maney.
Yes.
McLean.
Yes.
McCurdy.
Yes.
Morales.
Yes.
Trabulsi.
Yes.
Tuck.
Yes.
Valdez.
Yes.
Williams.
Yes.
Chair Latvala.
Yes.
21 yeas.
By your vote of 21 to 0, House Bill 793 will be reported favorably. Representative Lamarcus moves that bill drafting be allowed to make technical and conforming changes to the PCB pass in committee today. Show that motion adopted without objection. Representative Bell moves we rise without objection. This meeting is adjourned.